A search warrant is issued only upon establishment of probable cause relating to a specific offense. It is an order in writing issued in the name of the people of the Philippines, signed by a judge, and directed to peace officers commanding them to search for personal property described therein and bring it before the court. Search warrants cover the following properties: A. Properties which are the subject of the offense. B. Stolen, embezzled proceeds or fruits of the offense. C. Objects including weapons, equipment, and other items used or intended to be used as the means of committing an offense. The warrant must direct that it be served in the daytime unless the affidavit asserts that the property is on the person or in the place ordered to be searched, in which case a direction may be inserted that it be served at any time of the day or night. According to Administrative Circular Number 13, a warrant shall not issue but upon probable cause in late connection with one offense or one specific offense to be determined by the judge or such other responsible officer authorized by law after examination under oath or affirmation of the complainant and the witness. He may produce on facts personally known to them and particularly describing the place to be searched and the things to be seized, so that they could be properly identified. So the judge must, before issuing a warrant or a search warrant, personally examine in the form of searching question and answer in writing and under oath the complainant and any witnesses he may produce and attach to the record their sworn statements together with any affidavits submitted. Take note, class, that a warrant of arrest shall only be issued by the judge when there is a probable cause and it must describe one specific offense only. So, this particular offense, okay, must be determined by the judge or a responsible officer or a police officer or law enforcer that they need to examine, okay, under oath the complainant and witnesses. Okay, so the witness, okay, or the given statement of the witness must be personally known, okay, to them. Take note, personally known to them. And also, okay, the place to be searched or the things to be seized must be described, okay, in particular. So they could be identified or properly identified in the search warrant. Let's say that the judge is satisfied of the existence of the facts upon which the application is based, or that there is probable cause to believe that they exist. So it is a requirement that he must issue the warrant, which must be substantially in the form of uh, the prescribed rules. So the search warrant must be in duplicate, both signed by the judge, and the duplicate copy thereof must be given to the person against whom the warrant is issued and served. Both copies of the warrant must indicate the date until the warrant shall be valid and must direct it be served in the daytime. Take note that if the judge is satisfied that the property is in the person or in the place ordered to be searched, a direction may be inserted in the warrants that it may be served at any time of the day or night. Take note of this particular phrase. Okay? Any time of the day or night. In every court, there shall be a log under the custody of the clerk of court, wherein shall be entered within 24 hours after the issuance of the search warrant. So it must include the following: the date and the number of warrant, name of the issuing judge, name of the person against whom the warrant is issued, offense cited in the warrant, and the name of the officer who applied for the warrant and his witnesses. If after giving notice of his purpose and authority, the police officer is refused entry to the place of search, okay, halos parehas ito sa arrest. So, kunwari, hindi siya pinapasok. Sinabi niya naman the purpose is to conduct search, and he already showed the search warrant. Okay, so he may break open any outer or inner door or window or any part of the house or anything therein to execute the warrant or liberate himself or any person lawfully assisting him when unlawfully detained therein. So, allowed si police officer okay na mag-break, okay, manira ng door, window, or any part of the house, okay, or papasok or palabas ha. So, tandaan, kung siya ay na-detain na at alam niya na yung buhay niya ay in danger, so pwede pa rin siyang mag-break ng windows or doors or any part of the house. Okay? So, take note of the uh, rules na kinakailangan kay magiging legal lamang itong gagawin ni Mr. Police Officer kung siya ay nagbigay na ng notice. Okay? Nagsabi siya na yung purpose niya ay magsaserve ng search warrant okay, sa pamamahay ng owner ng bahay. Houses, rooms, or other premises shall not be searched except in the presence of their lawful occupants. Pag sinabi nating lawful occupants, siya yung may-ari ng bahay or miyembro ng pamilya ng nagmamay-ari ng bahay, or any member of the family occupants, or in the absence of the latter in the presence of two okay, witnesses of sufficient age and discretion residing in the same locality. So, kunwari, okay, wala yung may-ari ng bahay, pwedeng i-search yung bahay provided that merong dalawang witness na nasa legal age, okay, na naninirahan sa parehas na barangay or sa parehas na munisipalidad. Lawful personal properties, papers, and other valuables not specifically indicated or particularly described in the search warrant should not be taken. Take note that it is a rule in the search warrant na kinakailangang i-describe okay, ang exact location ng place na isi-search and yung bagay na isi-seize or yung bagay na kukunin. Maliban na lang kung ito ay contraband. Pag sinabi natin contraband, okay, it is obvious that it is against the law. Kagaya ng illegal drugs, firearms without license, okay, and so on and so forth. The search warrant shall be valid for 10 days from the date of its issuance. So, 10 days lang yung validity ng isang search warrant. Okay, what if hindi na i-serve ngayon ni police officer yung search warrant? Anong gagawin niya? Okay, he needs to surrender it to the judge or the issuing judge. Okay, what if he fails to submit it? So, he will be summoned, okay, by the issuing judge, okay, requiring him na mag-explain kung bakit hindi niya na-submit yung search warrant after 10 days. Okay, take note of that. The officer seizing property by virtue of warrant shall give a detailed receipt for the same to the lawful occupant. So, bibigyan ng kopya kay yung occupant o yung taong nag-witness or nandoon sa bahay during the time na na-serve yung search warrant. Okay, take note of that also. In the absence of such occupant, shall in the presence of two witnesses, kaya yung sinabi ko kanina, yung two witnesses with legal age, kaya na nanirahan sa parehas na municipality or barangay. So, iiwan ngayon yung list ng mga okay, kinolek or sinis na mga materials or items sa dalawang witness or any of the two. Okay? So, ibibigay yung listahan ni Iwan after the search. Warrantless search and seizure. The person is searched without a warrant for dangerous weapons or anything which may be used to constitute proof in the commission of an offense. The officer is also authorized to conduct search and seizure to the premises or surrounding as an incident to a lawful arrest. Example is seizure of goods concealed to avoid custom duties. Example is the paying of tax, okay, for goods. Persons exercising police authority under the custom laws may effect search and seizure without a search warrant in the enforcement of custom or custom laws. A search, seizure, and arrest may be made even without a warrant for the purpose of enforcing customs and tariff laws. For motor vehicle search, when a vehicle is stopped and subjected to an extensive search, it would be constitutionally permissible only if the officer conducting the search had reasonable or probable cause to believe before the search that either the motorist is a lawful offender or they will find the instrumentality of evidence pertaining to a crime in the vehicle to be searched. For example, kay pinara mo yung ikaw yung on duty, pinara mo ngayon yung sasakyan, huminto. Okay? Nung tinignan mo dun sa bintana niya, kaya meron kang nakitang baril. Okay? Nung tinatanong mo siya kung nasaan yung lisensya, wala siyang may pakita. So, are you allowed to search? Are you allowed to arrest the person? The answer is yes. Okay? Or during the chasing of criminals or perpetrators. So, na-stop ngayon yung vehicle. Are you allowed to search without search warrant yung motor vehicle? The answer is yes. There's no need for you to get or request for a search warrant. Seizure of evidence in plain view. The following are the requirements. The police and other concerned agencies must have prior justification for an intrusion. He or she is not a trespasser, or otherwise must be in position from which he or she can view a particular area. So he must not enter the premise, but to the fact that he can see it through his naked eye. The discovery of the evidence is plain view, or it is inadvertent. If we say inadvertent, the discovery was made by chance. It is immediately apparent to the officer that the item he observes or sees through his naked eye may be evidence of a crime, contraband. If we say contraband, these are materials or things that are against the law, like prohibited drugs, unlicensed firearms, and the like, or is otherwise subject to seizure. When there is waiver of the right or there is consented search, okay, ibig sabihin, pinayagan yung pag-search. If the citizen voluntarily surrender his gun, he or she cannot claim illegality of the seizure. Take note of the word voluntary. When a citizen waives his right and consents to the search and seizure, the police officer must ascertain or determine that he or she, in the first place, knows that he or she has such a right before he surrender it. So make sure as police officer or the police officer must determine that the person who voluntarily surrendering his or her firearm is aware that he has a right. Searches under stop and freeze. The police officer has the right to stop a citizen on the street, interrogate him, and pat him for weapons whenever he observes unusual conduct which convinces him that criminal activity exists. So take note, based on the observation of the police officer, uh, he may conduct a search on the uh, on a person or in a particular place where he believed that there is a possibility that criminal activity will exist. Emergency and exigent circumstances, a search warrant could be validly dispensed with in case of exigent and emergency situation, and the police officers have reasonable grounds to believe that a crime is being committed and they have no opportunity to apply for a search warrant from the courts because the latter were closed. So, for example, uh, it was already obvious, okay, that there is contraband, okay, in a particular place, okay. So, can there be a possibility that the search will be valid, okay, that is on emergency and exigent circumstances? Take note that with this particular situation, the consideration here is there must be reasonable grounds to believe that a crime is being committed, meaning the crime is uh, presently or okay, it is happening okay at the time that the officer okay uh, accidentally or notice that there is contraband in that particular place. Tip information. If the police officers have reasonable grounds to believe that the subjects are engaged in illegal activities, the tip information is sufficient to provide probable cause to effect a warrantless search and seizure. Take note, there is a tip information. If you say tip information, it was reported that there is illegal activity in the place of the subject where okay uh, being searched or the person who is being searched. So, for example, a concerned citizen called the police station okay to report about illegal activities. So this can be accepted. Inventory and delivery of the property seized. The police officer who confiscates property under warrant shall issue a detailed receipt of property or the seized property to the lawful occupant of the premises, or the owner, or the family members, or in the absence of such occupant, shall do so in the presence of two witnesses of sufficient age and discretion residing in the same locality, as I made mention a while ago. The receipt shall likewise include items seized under the plain view doctrine. The police officer must then leave a receipt in the place in which he found the seized property and a duplicate copy thereof with any barangay official having jurisdiction over the place okay, searched. The police officer must forthwith deliver the property seized or the seized property to the judge who issued the warrant, together with the inventory thereof, duly verified under oath. So it must include the complete list of the seized property. Thank you for watching this video. I hope so you will wait for the next video or for the next topic which will be discussed soon.